This Bill, first reading.
Tēnā koe, Speaker.
The Honourable Dr Peter Sharples.
I move that the Maori Purposes Bill be now read a first time. At the appropriate time, I intend to move that the bill be considered by the Maori Affairs Committee. This bill brings together amendments to a variety of legislation related to Maori affairs, including legislation affecting the estate of Puke Puke Tangiora, the Maori Fisheries Act 2004, the Maori Trust Boards Act 1955, and Te Ture Whenua Maori Act 1993. These changes seek to improve the administration of this legislation by updating provisions that have fallen out of date, monitoring legislation to ensure its continuing relevance is consistent with the government's statement on regulation. While these changes are largely administrative, they sit alongside a significant package of initiatives that contribute to the realisation of tino rangatirotanga, Māori self-determination. Firstly, the bill amends the legislation affecting the estates of Puke Puke Tangiora, a Māori matriarch, active in numerous reform movements during the late 19th and early 20th centuries. The original will of Puke Puke Tangiora came into effect upon her death in 1936. At various stages throughout the 20th century, the life beneficiaries under the will petitioned Parliament for relief from the terms of the will. These terms were modified by Parliament through provisions in various Maori Purposes Acts. These modifications date from a time when government interference in private matters was considered more appropriate than it is today. In particular, the 1943 Maori Purposes Act removed the provision of the will requiring estate assets to be retained within the estate for 20 years following the death of the last remaining life beneficiary. Estate assets will now vest in capital beneficiaries on the death of the last remaining life beneficiary. The 1943 and 51 Maori Purpose Acts have resulted in the Crown having more functions in respect of the administration of the estate of Puke Puke Tangiora than would otherwise be usual. For example, under the Maori Purposes Act 43, trustees of the estate are appointed by the Governor-General by order in Council. Typically, the appointments of trustees would be covered by the will itself, or would be performed either by the High Court or Maori Land Court. The Maori Purposes Act 1951 also provides for the Minister of Maori Affairs to approve purposes for which money may be paid to estate beneficiaries out of estate funds. The bill removes the role of the Minister of Maori Affairs and the Governor-General in the administration of the estate of Puke Puke Tangiora. And I must acknowledge the work of the past Maori Affairs Select Committee from the last season, and Tainoki tēnei wā, and particularly Mita Ririnui, who did a lot of work in Hastings on this. It recognises the involvement of this kind is inappropriate and interferes with the right of the estate to exercise control over its own affairs. The bill amends legislation affecting the estate in order to remove the minister's role in appointing estate trustees. It also removes the minister's role in fixing trustees' salaries and travelling allowances and approving purposes for which trustees may expend certain estate funds. To ensure continuity in estate administration, the bill confirms the position of the present trustees. The bill clarifies the jurisdiction of the Maori Land Court to appoint and dismiss trustees to the estate and hear all matters relating to the administration of that estate. This is consistent with the Maori Land Court's existing jurisdiction over Maori land trusts. The bill extends the period for which estate property will be held under the estate to 5 years after the death of the last remaining life beneficiary. Under present legislation affecting the administration of the estate would come to an end should the last remaining life beneficiary pass away. The estate property would then vest in the 9 whānau of capital beneficiaries. Extending the distribution period gives the beneficiaries of the estate 5 years in which to make decisions about the future governance entity to hold and manage estate assets. This mitigates the risk that the estate could come to an end before the beneficiaries have time to come to an agreement amongst themselves as to how to manage estate assets in the future. This bill also amends the Maori Fisheries Act 2004 to enable a transfer of mandated iwi organisations' status and fisheries settlement assets between separate entities operating within the governance arrangements of the same iwi. The Maori Fisheries Act does not provide for such a transfer, as it was not contemplated when the Act was developed in 2004. Should such a transfer be attempted, protective provisions of the Act would require the fisheries settlement assets to be offered for sale to the highest bidder from other mandated iwi organisations and Te Ohu Kaimoana Trustee Limited. This is an unintended consequence of the Act. There are situations where an iwi may wish to transfer their mandated iwi organisation status and fisheries settlement assets. For example, a number of iwi progressing through the treaty settlement process desire such a transfer to enable them to better consolidate and improve their governance arrangements and asset holdings. The Maori Fisheries Act should not prevent iwi from developing stronger and more efficient governance arrangements, which may ultimately better ensure the protection and value of their fisheries settlement and wider assets. The amendment to the Maori Fisheries Act is technical and remedial. It is an enabling provision only. Iwi may elect to use it or not, depending on their particular interests and circumstances. The amendment provides for the transfer while also maintaining the existing strict requirements of the Act regarding meal and the protection of the fisheries settlement assets. It exempts the transfer of the assets from the specific provisions that would otherwise require the sale of those assets. It will not compromise the rights and interests of beneficiaries of a mandated iwi organisation, MEO, or the rights and interests in other mandated iwi organisations, or iwi. This bill also amends the Maori Trust Boards Act 1955 to provide that for direct accountability between trust boards and their beneficiaries. Presently, the Maori Trust Boards Act requires trust boards to be accountable to the Minister of Maori Affairs for their financial arrangements. Trust boards are required to have their financial statements audited by the Auditor General. They receive their audited accounts from the Auditor General via the Minister of Maori Affairs. They must also send their annual budget and other financial information to the Minister of Maori Affairs for approval. This accountability relationship between trust boards and the Minister of Maori Affairs does not reflect the environment in which trust boards operate. It is also inconsistent with generally accepted practices for similar governance entities, which require primary accountability to exist between an entity and its beneficiaries. The bill amends the accountability relationship within Maori Trust Boards Act. Each trust board must now hold an annual general meeting to report to its beneficiaries on its activities and plans for the future. This includes the presentation of audited annual accounts, budgets, and other financial information. The bill also provides that the trust boards must have their financial statements audited privately instead of by the Auditor General. It replaces the role of the Minister of Maori Affairs in approving a trust board's annual budget with a requirement for a trust board to supply the Minister of Maori Affairs with audited accounts and an annual budget for information only. Finally, the bill makes various minor drafting changes to Te Ture Whenua Māori Act 1993 and Māori Incorporation's Constitution Regulations 1994 to allow for more effective administration of this legislation. So in conclusion, I thank those who participated in consultation on these amendments that provide the necessary updates to Māori Affairs legislation, particularly the last two Māori Affairs Select Committees. I commend this bill to the House.
The question is that the motion be agreed to.